Welcome to EU Privacy for All, Session 7 on the published GDPR, Articles 24 and 26, Controllers. The renumbering of Article 22 and 24 was 24, Responsibility of the Controller, and 26, Joint Controllers. In Article 4.7, the definition of the controller is provided. It means a natural or legal person, public authority, agency, or other body which alone or jointly with others determines the purposes and means of the processing of personal data. In Article 24, on the responsibility of the controller, it is laid down that taking into account the nature, scope, context, and purposes of the processing, at the risks of varying likelihood and severity for the rights and freedoms of natural persons, the controller shall implement appropriate technical and organizational measures to ensure and to be able to demonstrate that the processing is performed in accordance with the GDPR. Those measures shall be reviewed and updated where necessary. Where proportionate, it shall also include the implementation of appropriate data protection policies by the controller, and adherence to approved codes of conduct pursuant to Article 40 or approved certification pursuant to Article 42 may be used as an element by which to demonstrate compliance with the obligations of the controller. Article 26 on joint controllership lays down that if there are two or more controllers jointly determining the purposes and means of the processing, then they will have the obligation to establish in a transparent manner their respective responsibilities, in particular as regards the exercising of the rights of the data subject, by means of an arrangement between them or by means of union or member state law. The arrangement may designate a point of contact for data subjects. This arrangement shall duly reflect the respective roles and relationships vis-à-vis data subjects. It shall be made available to those data subjects. Finally, irrespective of the terms of the arrangement, the data subject may exercise his or her rights under the regulation in respect of and against each of the controllers. Another interesting input is laid down in Article 36 on prior consultation. When consulting a DPA, the controller shall provide this supervisory authority with the respective responsibilities of controller, joint controllers, and processors. The directive laid down in Article 2D on the definition of the controller that it is a natural or legal person, public authority, agency, or any other body which alone or jointly with others determines the purposes and means of the processing of personal data. It is quite similar to the one of GDPR. Article 6.2 also stresses that it shall be for the controller to ensure that the principles related to data quality, such as fairness and lawfulness, is complied with. What should accountable data controllers get prepared for? First, they should determine purposes and means decided upon with regard to the processing. This is exactly as in the directive. They should document appropriate technical and organizational measures, the TOMs, taking into account the nature, scope, context, and purposes of the processing, but also the risks of varying likelihood and severity for the rights and freedoms of individuals. They should review and update those technical and organizational measures. They will have to draft, update, and implement appropriate data protection policies accordingly. When two controllers jointly determine the purposes and means of processing, they are joint controllers and shall determine their respective responsibilities in a transparent way, that is to say, using an arrangement or based on EU or national law. They should also promote the adhesion to non-binding tools, such as codes of conduct and certification. They have to abide by many other obligations, such as records of processing activities, that will be further detailed in session 9. So finally, the key question is knowing how will the documentation of accountability be framed by the European Data Protection Board.